Hi, my name is Steve Gursten. I'm an auto accident attorney at Michigan Auto Law, and I have some exciting news. On August 1st, 2010, the Michigan Supreme Court came down with a new case called McCormick versus Carrier that is really important because it restores important legal rights to hundreds and potentially thousands of people who've been injured in car accidents, who have been completely innocent, seriously injured, and told by attorneys in Michigan that they did not have a case because their injuries were not serious enough. And what this new case did that came down on August 1st, 2010, is it returned our law in Michigan to the way the legislature intended when they enacted our law. And they returned our law to a more common sense approach that says, hey, if you suffered a serious injury like a fracture or a herniated disc or had a surgery, and you've missed weeks from work or months from work, that now will be sufficient, that you don't need to have a completely altered life like you did before under our old law of Kreiner versus Fischer, and that now it's enough to have sufficient lifestyle impact where, again, a serious injury and some impact on your normal life and a return to common sense will be enough. So for the people who've been seriously injured through no fault of their own and have been told that they don't have a case because they hadn't missed 6 months from work or a year from work and had major catastrophic injuries, thankfully that's no longer our law in Michigan. So if you have questions or if you've been injured in a car accident and it wasn't your fault and you're still suffering pain and having problems with your injuries, feel free to call us. We're happy to discuss your legal rights and explain how your rights have been restored after yesterday's court case of McCormick versus Carrier.